Oh, sorry. Okay, now the reason I required information pertaining to the aspects I requested, or I made a request in respect of to the defense as well as the state, was that as I prepared my judgment, I could not find my way through those aspects, such that I required clarity from the defense. For instance, the first of those is, did or does the business exist? What proof besides the accused say so is there that it exists? What prompted me to act in that fashion pertaining to that was that the applicant's case is to the effect that there was a travel agency that was being operated. On the other hand, the state says this was all a scam. Does that mean I have to start all over again? Okay. I was saying the reason I required information pertaining to the points I raised with the defense and the state was that as I prepared the judgment, I couldn't find my way through those aspects and required clarity. For instance, the first point is that did or does the business exist? What proof besides the accused say so is there that it did exist? The reason for requiring the information pertaining to that is that on the one hand, the state says there was a scam that was being perpetrated. On the other, the applicant's case is that there was a travel agency that was being operated. Now, I look at the investigating officer's affidavit, or at least he has a number of affidavits. One of them says, or is to the effect that the business does not operate. I look at that and then I say, Does it mean there was no business if it says the business does not operate? Or does it mean there was a business, but it has ceased to operate? Now, it would have been absurd of me to then, in those circumstances, in my judgment, make a pronouncement to the effect that there really was no business that operated, whereas every person around, perhaps even including the state, knows that actually there was this travel agency business, merely because I do not trust or I do not rely on the say-so of the accused. It appeared to me that is not too much of a contentious issue. Hence, I then required proof that at least this business exists or does exist but no longer operates. The second point is, as I've written it in my notes, is what do travel regulations have to do with Seedat and Patel, that brackets company's money? And then I write, i.e., was it used to book travel accommodation, etc.? And if so, what proof? What prompted that is that from attached to the applicant's affidavit is a document pertaining to the regulations for travel that there was a problem with. There's a letter also from Attorney here addressed to clients, which is to the effect that those clients would be paid, if I'm not mistaken, was it by November? But which payment has not happened. I then ask myself, what if I then hold that there was no business and that the travel regulation issue is just raised as a way of fobbing off clients? And it actually does turn out that there was a business that operated and there could be a valid reason for non-payment. But I was not proactive in asking the relevant questions or requiring the relevant information for it to be brought before me so as to enable me to come to a just decision. The matter of the passports was there from the onset of these proceedings, verification of those passports and all of that. But as at the stage of the judgment, there had been no verification. Hence, I said to both the state and the defense that perhaps you could assist pertaining to that aspect. I did raise this aspect of the strength of the state's case with Mr. Bamji as he was busy conducting the case of the applicant, and referred him to the matter of State versus Cock. Unfortunately, he seemed to be under the impression that all his client had to show was that she was not a flight risk. And I can see, and the prosecutor is correct, that what is now being done is to bring in information that over and above what I required is directed at weakening the state's case and or strengthening the version of the applicant. It would have been correct, therefore, as correctly pointed out by the state, for the defense to seek leave to place that other information before this court. Look, we would all agree, as you will see from my judgment, that the case of Supersad, which in any event I said should be given to Mr. Bamji to read, is a case in point here in certain respects. There's too many similarities between that case, though there are differences as well, and this one. Now, at page 11 of the Supersad decision, paragraph 33, it reads, the appellant, despite having sufficient opportunity to deal with the allegations presented in evidence, elected not to do so. This is surprising given the fact that the state presented its evidence prior to the appellant presenting the affidavit sworn to under oath. I am not certain why the respondent presented evidence first. Nothing more need, however, be said about the form of procedure involved, as the proceedings occurred over 2 days and sufficient opportunity had been given to the appellant to deal with the same. In addition, the procedure followed in the court à quo was not an issue raised on appeal. I must just point out that it is an issue now, as the state is objecting to the procedure. And then the judgment continues. He certainly could have utilized the opportunity to deal with this either by supplementing the affidavit or during cross-examination of the state witnesses by his legal representative. In essence, what it means is that there could have been leave sought in Supersad's case from the court so that the outstanding issues that were glaringly not there during the conduct of the bail application could be brought before this court, before that court. The same procedurally should hold true in this court. I do acknowledge that Mr. Ibrahim did ask whether he needs to do a reopening of his case. And my understanding at that point was to the extent that what I need is information pertaining to the points that I raised, which information was required by me. He did not need to get permission to reopen his case or leave to adduce any other evidence pertaining to those aspects. But as the state has correctly pointed out, evidence over and above that which I required is contained in the affidavit. There should thus be an application by the defense or the applicant made to this court for the adducing of such evidence. Otherwise, as I see it, in the absence of such an application, and to the extent that parts of the affidavit address the concerns or the information that I required, this court may simply strike those other aspects that are not properly before it off the record in order to be able to do justice to this matter. But then again, one has to consider this, that as I stated, I pointed the positive of the applicant's case to Mr. Bamji because I had in mind this case of supersat right from this time that the state wanted a postponement in order to get further information, because I could see that they are very similar cases. As I see it, and from the paragraph I read, the defect in the procedure by the defense of the applicant could be corrected if application is properly made, that in addition to the aspects already required by the court, they also bring before it evidence as to those other aspects that Mr. Bamji chose not to attend to. That is the problem here. In which event, and to the extent that this court has to play fair to both parties, the defense would have to address this court pertaining to the aspect of prejudice that could be done to the state if such as other aspects are brought before it, how it could be cured, perhaps by standing the matter down for the state to lead its own evidence or postponing this matter, things like that. But the state is quite correct that the affidavit goes above board. It not only addresses the aspects that are required, but also other aspects that in the first place could have been addressed by the first affidavit of the applicant. For instance, with respect to this matter of Gara, the reason I required further information pertaining to it, I sat there and I thought, on the state's version, the applicant wanted to flee, and at the time that the police went to arrest her, hid herself in the maid's quarters, as it is put there. It therefore, prima facie, shows she's a flight risk. But one thinks about these things, and then you think, if the applicant is such a flight risk, why would she not have fled all along? And the only fleeing mechanism she adopts is that when the police are there, she goes and hides at the maid's quarters. Does it not sound absurd? So you play around your head with these things in order to get your way through. And then I look at it, I ask again, but why must she be told by Kara what to do when the police are there if she does not want to flee? In my head, I then had it that if those aspects, as I requested information on, could be addressed, I would be better able to come to a well-reasoned and correct judgment. I will then leave it to the defense to decide what to do pertaining to the objection by the state, which I find to be valid to the extent that the affidavit addresses also other things that I have not requested to be addressed, which things should have been addressed either during the case of the applicant in her original affidavit, or because I sought to alert Mr. Pamji to these things, that is the applicant that must make out a case for release, even when it comes to the merits or the facts of the charges. You will see from the judgment I'm going to give that, if I'm not incorrect, it's Matabula's judgment, where it says it's not for the state to help an applicant in making their case in a Schedule 5 bail application. Matabula's judgment also refers to State versus Failure, where it is stated that it's for the applicant to show that she's likely to be acquitted on the charge. Those are Supreme Court of Appeal judgments. Hence, I brought that to the attention of Mr. Pamji. But as I say, I may well admit the affidavit, but strike out matter that is not required by me if the necessary procedure is not followed pertaining to the other aspects that are covered in the affidavit.
Thank you. May I address the court, Your Worship?
Yes.
Your Worship, I fully take cognizance of Your Worship's decision in the matter. Your Worship, in order to, and it is the defence's intention to bring such an application so that the court can condone the bringing of new facts in the supplementary affidavit. In order to do so, Your Worship, and just so that I have my facts straight, Your Worship, I just want to confirm, Your Worship, that the state is objecting, Your Worship, to two areas of new facts, Your Worship. The first being, Your Worship, the WhatsApp messages between the applicant and one of the complainant, and two, Your Worship, being the unabridged birth certificates, Your Worship, of the applicant's grandchildren, Your Worship. Your Worship, in respect of the other matters, I'm going to just go through the facts that have been put in, Your Worship, just to make sure that my colleague and I are both on the same page, Your Worship. Whether the business exists, Your Worship, the annexure of the search works of New Heights, Your Worship, was as a direct result of Your Worship's query as to whether the business exists, Your Worship. The effect of the travel regulations, Your Worship, the annexures therein, and the proof of payments that were made was as a direct result of Your Worship's question as to whether this business was just a farce or was there actually any payments made. The refunds, Your Worship, that was a direct result of the annexure in the first affidavit of attorney Mohamed Mia and Your Worship's query as to why the refunds had not yet been effected. Your Worship, the circumstances surrounding the arrest and Your Worship will recall that Mr. Kara previously gave an affidavit, Your Worship, granted this is a little bit more detailed, and that the new supplementary confirmatory affidavit of Riaz Malik, Your Worship, Your Worship, all relates to the circumstances surrounding the address as a direct result of Your Worship's question as to what had transpired and why did she hide in the back room and listen to Mr. Kara instead of presenting herself to the police at the front of the house. So, Your Worship, as I understand it, the state's objection is really on only two issues, Your Worship. That of the unabridged birth certificates and the WhatsApp messages, Your Worship. Your Worship, in respect of the WhatsApp messages, it's my submission, Your Worship, that entering the WhatsApp messages and allowing such evidence, Your Worship, to be before this honorable court is not only in the interest of justice, it also permits the matter to be properly ventilated. Your Worship, the WhatsApp messages demonstrate a sequence of events that occurred prior to the accused's arrest that led her to behave in the manner in which she did on the day of her arrest. It's directly relevant, Your Worship. It's corroborated by the fact that a case has been opened up at Lenasia police station, which I'm informed the investigating officer is aware of, Your Worship, and it also corroborates how the accused actually arrived at one of the complainant's premises where she was assaulted, and the reason why she was fearful of being assaulted again, and the reason why she then chose to hide in a back room until it was confirmed that these were in fact legitimate policemen that were there. Having regard to the fact, Your Worship, that an arrangement had been made with the investigating officer to surrender her. Also, what is important, Your Worship, why the interests of justice demand that Riaz's affidavit and the WhatsApp messages should be entered into the record, Your Worship, is very simple, Your Worship. The investigating officer gave evidence before this court. His evidence, Your Worship, and we can go back to recordings, was that he had attempted to make telephonic contact with her on numerous occasions, Your Worship, and for 6 months he was unable to get hold of her. That was his version of events. Not once, anywhere, in his evidence before this court, did he in fact inform this court that not only had the accused made contact with him, the accused had sent her nephew to him while she was in Durban undergoing medical treatment. Not some random nephew, but Riaz, who then made an arrangement to surrender the accused. And it begs the question, Your Worship, had this information been available to the defense at an earlier stage, Your Worship, or had I had the opportunity to cross-examine the investigating officer, certainly he would have a lot of questions to answer on that. It appears, Your Worship, that this court was deliberately misled by not giving the information, and it greatly assists this court, Your Worship. The state has, Your Worship, is not entirely disadvantaged. The state, Your Worship, at this juncture, would be quite entitled, Your Worship, to recall the investigating officer to the witness box, Your Worship. I'd relish the opportunity to cross-examine him, based on the facts that are now before me, Your Worship. So, Your Worship, in properly ventilating this matter, it's important that the court gets to the truth of the matter, Your Worship, and gets to a situation where the matter is ventilated, taking the accused's rights into account, taking the state's interest into account, balancing that against the community interest. It can never be said, Your Worship, that any information which properly assists this court to properly ventilate this matter should be refused. And, Your Worship, if the state so chooses, Your Worship, and if you assist this court in any way, Your Worship, I'm quite happy, Your Worship, to call the deponent to a supplementary affidavit, Mr. Riaz, to the witness box, so the state has an opportunity to cross-examine him as well. That in itself, Your Worship, should eliminate any prejudice that the state may say has been occasioned by the adducing of the new evidence. The state could have stood this matter down, confirmed the facts with the investigating officer if that was indeed correct. The state chooses not to do that. It's therefore not that the state has been prejudiced, Your Worship, it's that the state is choosing not to interrogate these facts that have been put before it, Your Worship. The prosecutor, Your Worship, as a colleague in court, has an inherent duty, Your Worship, an inherent duty whilst he has a job to do. That this court is properly, Your Worship, equipped with every information that will assist this court in coming to a proper determination. The impartiality of members of the prosecuting authority is well dealt with, Your Worship, even in Hemstra. Now the question it begs, Your Worship, is what prejudice will the state suffer if these facts are indeed correct? If indeed an arrangement was made with the investigating officer, how would it prejudice the state's case in any form or manner, Your Worship? Over and above that, Your Worship, the investigating officer should be a little bit impartial in this matter, and coming to court and giving evidence in the witness box and forgetting large chunks of his recollection as to what had happened in securing the accused attendance, Your Worship, cannot be, Your Worship, written off as an oversight. An arrangement was made. Your Worship, with respect to the birth certificates, it's not the first time, Your Worship, that these birth certificates have actually been presented, Your Worship, to the state. In fact, Your Worship, I will confirm and I'll place it on record that I personally have given as an investigating officer copies of these birth certificates, Your Worship, and copies of the applicant's personal documentation for the verification. Not a single shred of evidence has been put before this court, Your Worship, as to what attempts have been made by the state to attempt to verify the passports. In fact, nothing has been done, Your Worship. It's been an absolute deliberate attempt not to verify the passports. Had it not been for the defense, Your Worship, there'd be no verification before this court. Your Worship, the unabridged birth certificates, Your Worship, for what they're worth, are the birth certificates of the accused grandchildren. Your Worship, unless the state is alleging that they're fake birth certificates or they're fraudulent in some form or manner, I can see no harm that it would cause to have these birth certificates before this honorable court, to place the personal circumstances of the accused before this honorable court. Your Worship, in summary, Your Worship, the state has an objection
that you must apply to reopen your case, or at least to be given leave to place the other additional information before this court.
Yes.
Of course, it's also a sort of reservation of rights by the state, as I see it, to the extent that they may well want to reopen theirs and challenge those aspects in the affidavit relating to information not requested by this court. Or am I getting you wrong, Mr. Mko?
Not at all. If I may address Your Worship in that aspect.
Yes.
Your Worship, it's entirely correct, Your Worship. This is an application, Your Worship.
In essence, he says, the court has a discretion, but that discretion does not mean that a party is given carte blanche to bring whatever information it wants to bring before the court, merely because they've been asked to address certain things or bring information pertaining to certain things.
Your Worship, if I may address Your Worship. Your Worship, the prejudice that the accused will suffer, Your Worship, should this evidence not be allowed, Your Worship, should this annexes to these affidavits not be allowed before this honorable court, Your Worship, is immensely greater than any prejudice that the state would suffer. Your Worship, there can be no greater prejudice than denying a person their liberty, Your Worship, incarcerating a person and denying them the freedom of their liberty, Your Worship. Any prejudice that the state may suffer, Your Worship, can be, as you've correctly pointed out, Your Worship, can be cured. The matter could be stood down or adjourned, Your Worship. The state is entitled, Your Worship, to revisit, to look a little bit closer at the information that has been provided and to rebut it if they can, Your Worship. The state, Your Worship, reopen.
Reopen.
That is correct, Your Worship.
If this done, I want to reply, Worship, to the certification.
Yes.
I take it is done, because at one stage I thought he was not bringing the said application. Worship, the state will be opposed to the said application being brought, Worship. And the reason why the state is objecting to the said application being granted to the court, Worship. Number one, bail proceedings are urgent in nature. And there's a principle of finality. This kind of matters needs to come to finality, Worship. Now, my colleague is not stating the grounds why this information was not adduced when they were leading evidence. Because I'll refer this court to the case I've referred the court to, Your Worship, to both case law of the Supreme Court of Appeal being S versus Ndwin as well as S versus Board. Look, they state clearly that there should be a reasonable, sufficient explanation based on allegation, it may be true why the evidence which is sought to be led was not led at the commencement, Your Worship, of a trial of bail application. There's no substance that have been placed by my colleague. Why this evidence was not led when we first commenced with this bail application, Your Worship. Evidence that was already in their possession, because he's not making an allegation of saying, subsequently to the postponement of this matter, we came into contact with this or in possession of this evidence. For instance, he makes evidence of saying, the applicant was in KZN receiving medical treatment. That is why he was not found in her house. Why was that evidence not placed when we commenced with this bail application? Why they did not specifically say, at one stage the applicant was in KZN receiving medical treatment? They further making allegation of saying, applicant was assaulted. He opened a case. Why did they did not allege this when we commenced with this bail application? Did they subsequently come into possession of this information, or it was there all this time, Your Worship? They're saying it's a case that transpired last year, November. Clearly, they were already in possession of this information when we started with this bail application, Your Worship. However, they opted not to adduce it. They even referred to a case, to the case number 18 of 11, 2019, indicating that the case was open already at the police station. They're not indicating why this information was not disclosed initially when we started with this bail application. Why this WhatsApp message was not provided. Why this proof of payment was not provided. Why this proof indicating that, in actual fact, there were complainants or other members of the society that actually went on this trip in December or November. Why did they not provide this information? There's no explanation whatsoever. One thing that you must see, because section 60, subsection 11, paragraph B of the Criminal Procedure Act 51 of 1977, it says the accused must be given a reasonable opportunity to adduce evidence. Accused was arrested on the 6th of April. Today is the 6th of May. More than a month we've been doing this bail application. That is more than reasonable time to have afforded the applicant an opportunity to adduce this evidence. That's what the section says. We must afford a reasonable time. The state will say, she has been afforded more than reasonable time, Your Worship. At one stage, the state was applying for postponement, which was vehemently and strongly opposed by my Leonard colleague. It was granted the postponement, I think, of 2 days. Why did they not adjust that evidence prior to the state commencing with their case? It's a pity Mr. Banj is not here, but Mr. Abraham was present on the last occasion. The state finished them with the investigating officer's statement, as well as the 2 other statements I've handed in. They were aware all along of this evidence adduced by the investigating officer. However, they opted not to rebut that evidence prior to the respondents commencing with this case, Your Worship. So the other prerequisite that must be met by the defense prior to their case being opened, Your Worship. Just a moment. Just a moment. This, and it refers to the very same, it's mentioned in the very same case I referred to. When the court is adjudicating such an application, it also needs to look at the possibility that it may have been shaped to relieve the pinch of the shoe. It's clear in this case that they want to adjust such an information in order to relieve the pinch of the shoe, because they're not explaining why such an information was not adjusted. To allow them to do so, Your Worship, will be to unnecessarily be prolonging these proceedings, because there will be a prejudice to the state. My colleague is saying, what prejudice can be there to the state? My colleague forgets to look at the fact that justice is twofold. There must be justice done to the applicant, and also justice must be seen to be done, not for the state, but for the public the state is seeking to represent, what will the public say? The applicants start their case, they close it, the prosecutor do their case as well, and the applicant is given another chance to have a second bite at the cherry. They'll just say this proceedings is amounting to mockery. Because the said application is not for the taking. It has to be substantiated. There has to be substantial substance before the court indicating why such evidence was not adduced when you commenced it with this bail application. None has been adduced whatsoever. Because we've seen numerous cases. The very same case I referred the court to, where it was the prosecutor bringing the said application, the other one it was the defense bringing the said application. They said due to the incompetency of the other one, said due to the incompetency, or the not incompetency per se, but due to the experience. They said due to the inexperienced prosecutor or the attorney or advocate that did the case. Oh, we saw Mr. Bunch is a very experienced attorney. Cannot be said it was due to the inexperience of Mr. Bunch why this evidence was not adduced. No reasonable explanation. Even though they've been given reasonable time to adduce this evidence, no reasonable explanation as we stand now is being adduced to the court why this evidence was not adduced. My colleague merely says, I don't know why my learned colleague did not adduce it. But he was sitting here next to Mr. Bamji. He was a co-counsel in this case. Why do they not state a reason before court? Reasonable explanation. Why was this evidence not obtained? You had this evidence all this time. Are you trying to relieve the pinch of the shoe or having a second cherry at the bar? The second bite at the cherry? Clearly, they don't have grounds or reasonable explanation why they want their case to be reopened. The state will submit such an application should be refused due to the fact that it will unnecessarily prolong these proceedings. Because the state, there definitely will be a prejudice to the state, because I will need to reply to this to the allegation made. If I'm not allowed to reply to the said allegation, state will be prejudiced. I'll need to speak to the investigating office and see if indeed there is a case registered with this case number, and is the applicant really the complainant in that case? Did she depose to a statement? Because if my colleague wanted to truly show that there is such a case, they could have easily requested a copy from the investigating officer of that case and say, finish what's with a copy of a docket as well as a copy of a statement of the applicant, indicating that she has deposed to a statement. We see when the statement was made and commissioned when. None is before court, So if the admission of they are allowed to reopen the state case, the state will have to consult the investigating officer and request the investigating officer to obtain such evidence, and so that the state can place it before the court, in order to avert any prejudice that might be suffered by the state representing the society. The state will submit that such an application brought by my colleague should be refused, in light of the fact that there are no reasonable explanation before the court as to why such evidence was not adduced when you commence with this bail application. No further submission.
Your Worship, I'm going to attempt to try and simplify the dilemma we find ourselves in, Your Worship. But I need to first, Your Worship, address several issues that my colleague has raised. Your Worship, it was never said at any point in time, whether when Mr. Bamji was on record or I was on record, that the accused did not present herself because she was in KwaZulu-Natal. That's completely misleading and incorrect. Your Worship, the assault case, Your Worship, my understanding is that the current investigating officer that gave evidence is the one that has a docket for the assault case, Your Worship, which he hasn't disclosed to us. Your Worship, in respect of the WhatsApp messages and why this was not disclosed to us, my colleague forgets that we're currently in a COVID-19 level 4 lockdown, and we were previously in a level 5 lockdown. Consulting with the accused in prison is not as easy as it used to be before, and even before, Your Worship, it wasn't easy. Your Worship, the proof of payments that have been provided is a direct result of Your Worship's questions. Your Worship requested such information. The trips in December that were undertaken is a direct result of Your Worship's questions as to whether this is in fact an operating business or is this just a sham to take people's money, and which demonstrates that adequately. Regarding the comments from my colleague regarding Mr. Bamji, it's entirely correct, Your Worship, that I was present when Mr. Bamji was addressing this court. Mr. Bamji is a very competent and senior attorney in the profession, and by no means, Your Worship, am I going to advise Mr. Bamji, Your Worship, or with the benefit of hindsight now, Your Worship, and having come into possession of information, throw him under the bus, Your Worship. That I won't do. Your Worship, the need to reply, should the state need to reply? It's my opinion the state has to reply, Your Worship. And my colleague keeps using the description, pinch of the shoe, Your Worship. It's very different when there's no shoes worn. And that's the situation that the state finds themselves in at the moment. But to assist the state, Your Worship, because my opinion, Your Worship, is the new evidence which the state is so adamant is going to damage and irreparably prejudice the state's case in the matter happens to be the WhatsApp conversations. My instructions from my instructing attorney, Mr. Latibu, who is present here today, Your Worship, is that, Your Worship, we agree that the WhatsApp conversations and the annexes that are attached regarding the WhatsApp conversations can be struck, in which event I do not need to bring an application before this court to reopen my case, Your Worship. And my understanding is that is the only objection of the state to new evidence, Your Worship. And in regards to the cast number being struck, Your Worship, I agree to that as well, if that will assist the state in any way.
I'm
not in position of the affidavit, but they keep on confining themselves to this few aspects. They mentioned
you should have read the affidavit.
Yes, I think that would be better, so that I can.
Otherwise, you're going to have the same oversight as happened when I raised Koch's case with Mr. Bamji. And you correct, Mr. Abraham was also here. And they overlooked the aspect of the state's case. And I tend to agree, if I were to be frank with the state, that even these aspects that are raised, I was very careful in raising those aspects because at the end of the day, those aspects should have been there during the conduct of the applicant's case. And in Schedule 5 bail applications, as is stated in this case of Supersat and the most recent case of off-road by the Supreme Court of Appeal, it is the community's interest that takes precedence over the interests of the applicant. So I had to bear that in mind even as I requested the information, because one does not need to be a rocket scientist to note that even these aspects that I wanted to be raised, that I raised, somewhat help the applicant's case. And as per this case of Supersat, I may well have not raised those aspects and continue with judgment. I shall stand the matter down then for the state to read the affidavit and will return back to this thing. Yes. I don't want information to go missing. Can you also pass this to?